Mr. Berger?
Good morning. My name is Lee Berger, and I represent the appellee, the defendant, Francis Klemm. The complaint in this case is based entirely on Chapter 214, Section 1C. That statute provides that a person has the right to be free from sexual harassment as defined in Chapter 151B and 151C. The definitions in those statutes require either an employment or an academic nexus, neither of which are present here.
Okay, if that's required, and it's limited to Chapter 151B, why do we need 214.1C?
In Guzman v. Lowinger, this court held that there is a gap.
The 6 people in the list, and you think that's all it's limited to?
Well, there's another section. I think there's another exclusion in the term of employee for domestic servants. So this would also allow a domestic servant, an employee, to be considered an employee and have the rights under the statute.
Why doesn't as defined in means what constitutes sexual harassment is defined in 151B?
I'm sorry?
Why doesn't the term as defined in, why isn't that intended to help define the term sexual harassment?
Well, I think it does. I think what it does is it says that it's to be actionable. For a sexual harassment claim to be actionable, you have to meet the requirements of sexual harassment as defined in that statute. And those requirements specifically talk about terms of employment, affecting and interfering with the terms of employment.
Well, what does work environment mean? Do you have to be employed for monetary gain in order to be in a work environment?
It's interesting. In 1987, Chapter 473, Section 2 of the Act of 1987, deleted the word or between A and B in that definition. And I suggest that clearly the work environment made reference to the concept of in employment. I mean, certainly the legislature had it intended to had it intended to expand the class beyond employees who were paid, could have done so. Chapter 258, Section 1, the State Tort Claims Act, defines a public employee as somebody who is not only paid, but an uncompensated employee for the purposes of that act. For the purposes of this act, employee is not defined that way. It's simply defined, frankly, in the negative as to who's not an employee. But the legislature certainly could have explicitly said that they wanted to define it as uncompensated employees if they wanted to.
Well, are you saying that the legislature intended not to include volunteers in sexual harassment claims?
For this particular statute, yes. This particular statute allows the remedies of 151B, Section 9, and that includes punitive damages. There's a distinction between volunteers and employees. Volunteers don't depend on this volunteer.
But you agree a volunteer and an employee could be in the same space, interact with the same people, have the same conditions apply to them for all purposes, and yet you'd have two different groups.
Volunteers don't depend on the employer for their livelihood, their incomes, their mortgage payments. They can walk away.
But
there is a distinction.
No, go ahead.
You know, the legislature treats different employees differently all the time.
But volunteers oftentimes enter the workforce with the expectation that they will be hired. And they will sometimes be working side by side with paid employees, doing the same task.
That may be, but they certainly have the decision as to how to. We're talking about social policy, and the social policy is something the legislature can and should address if they want to do this. Should this one statute protect everybody?
Well, the statute.
But it's not. I'm sorry.
The statute also refers to the academic environment.
Yes.
Does a student, for instance, have to be taking a course for credit as opposed to auditing the course in order to be protected by the by Chapter 214, Section 1C?
That I I haven't researched that issue, and I understand that there's some sort of an analogy
Well, is there a
there,
difference
but-
between a student who is enrolled at the university, paying fees to the university in a degree course of the university, and is, quote, auditing a course, as opposed to what happens in numerous universities who want to have good relations with the community? Anybody can breeze in on a given day and breeze out whether or not they want to complete the course. I mean, there's a difference between auditing and people who just come in for one lecture, who may be, quote, auditing, but who are not otherwise connected to the university. Surely there would be a difference, correct?
Sure, there's a difference. People have spent money and expect to be treated with respect. Volunteers, I don't mean that volunteers don't also expect to be treated with respect. Volunteers have rights. They have common law tort remedies for sexual harassment. They can file a claim under the Civil Rights Statute, but they don't have a claim under this particular statute.
And I take it employees would not have those rights. Is that correct?
Employees have been excluded from those rights under Guzman, under Green versus Wyman Gordon, and the Doe versus Purity Supreme case. This court specifically said in Doe that Doe was an employee who was raped, and she filed a claim. She didn't go through the MCAD process, and this court said, no, you have to go through the MCAD process, but only because you're an employee. So in that instance, the volunteer would have had more rights. Basically what the court said is that Chapter 152, the Workers' Comp statute, it was exclusive and barred them from an employee from pursuing a common law tort claim. As you know, under that statute, you can't get pain and suffering. Well, a volunteer could pursue a pain and suffering claim for a common law tort of sexual harassment. So it's not a matter of saying that you're getting less or more rights. I mean, this is an issue that the legislature has addressed, could address. The legislature was well aware in 2002, when it amended this statute, of this court's decisions back in 1996 with the trilogy of Green and Guzman and Doe. It was also well aware of the Comey versus Hill case, which said that an independent contractor cannot pursue an age discrimination claim under 151B. So it understood that this court was limiting 214.1c to only employees and students, perhaps, although those cases didn't deal with students specifically. It understood that this court was limiting the claims to employees, yet it did not change the definition.
Does the legislative history indicate that they intended to exclude volunteers?
The legislative history is interesting. It's basically laid out in Guzman, and it's also which quotes the Clark versus Kentucky Fried Chicken case, where it specifically, there were 8 bills, and the only language that was deleted from those bills to form this particular bill would have made it unnecessary to file a 151B claim before pursuing a 214.1c claim. And what this court said is that the deletions of limiting language from predecessor bills is normally presumed to be intentional. So first, the legislature intentionally decides that filing a complaint with the MCAD under 151B is a prerequisite to filing a complaint under 214.1c when the employer had 6 or fewer employees. And second, knowing the holding in Comey versus Hill, decided 4 years earlier, in 1982, the legislature intentionally defined sexual harassment only in the context of the employment or academic status.
Mr. Berger, let me ask you this, and which I'll also ask Mr. Orm. In this case, as I understand it, the alleged victim was a volunteer, but the alleged perpetrator was an employee, correct?
Correct.
If we were to agree with the interpretation of the appeals court, would that mean that an employer would be held liable, potentially for punitive damages, if the sexual harassment was perpetrated by another volunteer?
Volunteer against...
On volunteer.
On volunteer. In other
On
words,
volunteer. Neither being within the...
No, I understand that, but assuming that we were to agree that the definition under any one of the theories that's been suggested, that the statute covers volunteers, would that mean necessarily that if a volunteer perpetrated a sexually harassing act on another volunteer, an employer could be held liable for the full damages under 151?
I think that's certainly possible, and the problem there, of course, is that the employer doesn't have control over the volunteers, as it does have control over its employees. It can fire its employees. It can't fire. Well, in this case, it sent a no trespass notice to the employee.
Well, I'm thinking, for example, of employers, many of whom may be tax-exempt organizations, not-for-profit organizations, and they rely on many, many hundreds of volunteers, for example, in connection with a major benefit. People volunteer for one night, or maybe they volunteer for 6 or 7, nights, or they stamp envelopes or do something. And, if on that one occasion one volunteer perpetrates a sexually harassing act on another volunteer, does that mean that the employer, the American Heart Foundation, or whoever it is liable for those acts?
Well, to begin with, I don't think that this statute would apply, but if it did apply to volunteers, I'm not sure how you can say it doesn't apply in your scenario. I would like to point out one particular statute where the legislature treats the exact same employee, essentially, completely different from another employee working side by side, which is, the appeals court talked about, how absurd it would be just because they're working side by side and they should have different remedies. Well, 151, Chapter 2B, provides that employers of certain migrant farm workers have to have compulsory health insurance. Yet somebody living in Massachusetts, working side by side as a farm worker with those migrant farm workers doing exactly the same work, doesn't have that benefit. It's a matter of social policy. The minimum wage law, $6.75 an hour for most people, $1.60 an hour for agricultural workers. Some people are totally excluded from the minimum wage law, restaurant workers, hotel workers. This is social policy. There are arguments, yes, that's a good idea. No, it's not.
I understand that point, but we're really just trying to interpret a statute here and what the legislature intended in this context. Whether there's social policy implications or not is not ours to say.
Well, the legislative intent, you just have to look at the basic principles of statutory construction. And that has to do with the plain meaning of the words, no words in a statute are superfluous, and the concept that generalities within a statute yield to the specifics within that statute. And I suggest that the appeals court decision renders the words as defined in Chapter 151B and 151C entirely superfluous.
Could I ask you this, Mr. Berger? We know, and we will cite it frequently, that the chapter, because the legislature has said that the chapter shall be construed liberally for the accomplishment of its purposes. How would you define its purposes?
This court defined the purpose in Guzman versus Lowery, said that Chapter 588, which is what created this, was a comprehensive scheme to eradicate sexual harassment in the workplace. And it further went on to say that this particular section, Section 6 of 588, which enacted Section 1C, was for the purpose of eradicating that gap left by 151B15 about the 6 employees or less. And that was the purpose. That's what this court said was the purpose.
How do you deal with the plaintiff's argument that in the amendment there's a specific provision that says nothing contained in this chapter shall be deemed to repeal any provision of any other law of this Commonwealth relating to discrimination, other law including Chapter 214, Section 1C. And I say that because if you read the statute as a 214C before 2002, I think there's at least a reasonable argument that a person shall have the right to be from sexual harassment, as defined in Chapter 151B. I mean, then you go back to Justice Cowen's question whether it's really defining sexual harassment, not whether or not you have a cause of action under 151B, which is the post-2002 legislation, correct?
Yes. 151B is post-2000.
So you would say that neither 214, your argument is that neither 214 Section 1C before or after 2002 covered volunteers.
Correct.
Okay. Thank you, Mr. Berger. Mr. Orm.
Thank you, Chief Justice. My name is Kevin Orm. I'm representing Lorraine Lowery, and it's nice to be here from Cape Cod. The object.
If you're right, doesn't this statute more or less supplant 151B altogether?
No.
No?
No, Jeff. The 151B purview is employer-employee. That takes care of a great number of people, but it doesn't take care of all persons. There are instances where the relationship in a workplace is a volunteer as opposed to a worker. In fact, in Judge Berry's decision, she talked about the candy striper in a hospital setting being sexually harassed by a doctor and a nurse in the same setting being harassed by a doctor.
Well, they're not without remedies. I mean, they have different remedies.
Understood. The question is whether 1C covers the candy striper. It certainly does not cover the nurse.
What do you do?
But why does it not cover? Let me put it this way: why, to go back to Justice Glaney's question, why would Chapter 214, Section 1C, not cover the nurse? Because the 151B is a more specific.
151B, where it applies, is exclusive.
Yeah. But if that were correct, I mean, it seems to me one of the problems is that volunteers would then have more rights than employees because they could bring their action under Chapter 214 and their common law rights, face no workers' compensation exclusivity bar, no administrative requirements under 151B. Volunteers would have more rights than the employees who depend upon this for their livelihood. There is something odd about that.
Absolutely, if it were true.
Why isn't it true?
It isn't true because in this case, and we only deal with this case, the claim was brought under 214.1c.
Oh, I know you've only brought this
The
claim.
volunteer had coverage under 214.1c because she was a person. She was not an employee. Therefore, she could not bring a claim under 151B.
Right, but
she was not a student.
But she can bring a negligence claim. She can bring a claim for assault and battery. She can bring a whole array of common law claims as well. I know you didn't do it in this case, but a plaintiff in your client's position could bring all those claims in addition to their Chapter 214 claims, and not, as I say, not face the workers' comp exclusivity bar.
Justice Soseman, I think the real distinction here is between a person who is suing for sexual harassment, and you're naming a variety of other statutes which, for instance, the workers' comp statute, which my brother, Mr. Berger, has already pointed out, does not give a person, an employee who is injured at work, anything except for a limited compensation.
Right, and takes away a lot of other rights.
It does. In fact, it did so in 1939 with the Johns Mansfield Company up at Saranac Lake in New York.
Could I also ask you, in terms of when we have this cross-reference to the definition in Chapter 151B, you seem to want to cut the definition off before the important word when.
I'm sorry?
You seem to want to use only that first, whatever it is, 19 words or whatever, of the definition, and then cut off the word when. and everything that follows.
Which talks about work and employment and so on.
You know, you're saying that it only means that sexual harassment shall mean sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature, period. You're saying that's the definition that you want to apply.
And the reason I say that is this. We come to an illogical result if we don't say that. In other words, if you read the statute, when we get past a person shall have a right to be free from sexual harassment and go into, as defined in 151B and 151C, we begin to see numerous problems. The first problem would be that a person looking to recover under 1C, if he had or she had to meet both the 151B and the 151C.
We can construe a statute in a way to avoid absurd results.
And that
I think
would be
we
an
can.
absurd
I think
result.
we can avoid the absurd result that you are suggesting when that flows from the word "and." It seems to me the absurd results that potentially flow from your interpretation is that it covers, a guy who, whistles at pretty women walking by on the street.
No, it would certainly require more than a whistle at a pretty girl
No,
on the street.
you may say that doesn't define sexual harassment,
It does not.
but it may define person the way you're defining person.
It would.
Well,
Could I ask you to address my hypothetical?
Judge, you raise a point when you ask, what about a volunteer sexually harassing a volunteer
Right.
that has been addressed in a case? I was looking for it while we were talking, but it took place in a radio station. Both parties to the alleged sexual harassment were volunteers at this radio station. And that case, I believe, said that there's no cause of action when it's a volunteer vis-a-vis a volunteer.
When the volunteer is the perpetrator?
For purposes of
When the volunteer is the alleged
where the perpetrator is a volunteer, there's no cause of action.
against the radio station.
Against the station as the employer, non-employer.
And presumably that's because the employer, quote, doesn't have any control over the volunteer.
Exactly.
Right?
Respondeat superior would prevent there being liability for the employer in that case.
I mean, could I come back to this? I mean, if we cut the definition off before, and stop at the word when, it doesn't, that part of the definition doesn't even include any reference to the sexual advances, requests, or conduct being unwanted.
No, Judge, it does not.
It does not.
What we also
I mean,
don't
it seems to me
have-
it does put people in a precarious position that, that the request for a kiss at the end of a date, if that request turns out to be unwanted, is sexual harassment, actionable sexual harassment under your definition.
Judge, if the person in the workplace was an employee, you couldn't even look, and I couldn't even look when I brought this case, to bringing an action under 151B. The reason being that it specifically states that the person who seeks to be protected under 151B must be an employee. As far as my way of thinking of this, in a sense it's a mathematical way of thinking of this, you have a concept of Venn diagrams. The universe is the universe of all people. A subset of that universe is employees. As far as the employees are concerned, their exclusive remedy is 151B. No doubt about it. No one has argued to this point, and no one is going to argue that issue, which is long since decided. If the person is a student and is sexually harassed in the academic environment, there is no question that that's another separate and distinct subset within the universe of persons. It doesn't overlap with 151B, where it's an employee. It's separate. There are two. And when you think about the purpose of 214.1c, I suggest the purpose is simply to supplement 151B. It does not supplant 151B. And if you look at the words in the entire statute of 151B, you will note there's never a mention of an employee. There is no mention of employee.
Well, but except there is after the word when in the definition.
No, there's
It's
not
gotta
the
be-
word. There's a reference.
The submission or rejection of the has to be explicitly or implicitly a term or condition of employment or a basis for employment decision. So clearly, employment has something to do with
That's in
subpart
151B.
Yeah, I mean but that's the definition of sexual harassment. It includes that.
For purposes of 151B, what I suggest you have to do in order to get to a harmonious result with these statutes is you have to take that portion of 151B that is mirrored in 151C. That portion says that sexual harassment involves unwanted sexual advances. It can create a hostile work environment under 151B, 118B.
I mean, the problem is, I hate to keep coming back to this, but if you stop before the word when in both definitions, under 151C or 151B, it doesn't even include any reference to unwanted. You're reading that in.
I am taking from 151B, Section 1, Subpart 18, and I am taking the beginning of that and the beginning of 151C, which are identical.
Do you have to go that far? I mean, couldn't you, to sustain your position, and I don't think you argue this, though, hit it head on and say the words we're focusing on in the definition, namely conditions of employment, work environment, employment decisions, are broad enough to cover a volunteer? Because a volunteer goes into wherever they're going, and they say to them, well, you're a volunteer, but lunch hour is 12 to 1. You can't leave till 4. Work environment certainly would cover a volunteer. Couldn't they be reconciled in that way?
I think there is a way to reconcile.
But you don't argue that, as far as I can see. You argue more of what Judge Sossman is saying, that you stop everything at the word when.
Judge, I know I went as far as to say that we should take that part of 151B that defines
I mean, a volunteer is an unpaid worker, an unpaid employee, really, for purposes of what's being done for whatever period of time that volunteer is at the place where he or she is volunteering. And
there
usually,
may be some
conditions are imposed on them.
There may be some gloss that we want to put on this in terms of the length of time. We've talked about a person walking down the street and being whistled at. I don't think that's going to amount to sexual harassment.
That would exclude that problem from this.
I think it would. We take that out. There has to be severe, continuing harassment.
That's whether or not it constitutes sexual harassment. What's interesting to me about the appeals court opinion is that it purports to cover a volunteer worker. Now, there are lots of workplace definitions, but the example I gave, of a one-day work, somebody who comes in for 1 day, sits at the table, taking tickets at the entry to the Marriott Copley, has no other connection with the American Heart Foundation or whatever it is. Is that in the workplace? That's fundraising, very important. Is that in the workplace?
I think it's too tangential.
But how do we know?
I think you have to look at the individual case. This is a person, Lowery, who was working for 3 years in
No, I understand in this
proximity
case,
to this
but we
person,
we
Klemm.
have to, set some limitations. In other words, one can, I think, draw that inference if you go to the full definition of Section 18 of 151B, Section 1.
In particular with the hostile work environment, I think.
Thank you, Mr. Orme.
Thank you.